This is now being live streamed. Hear ye, hear ye, hear ye.
Are we recording? It doesn't look like it. Oh, there we are. Sorry, Matt.
I apologize. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Good morning. Today is September 14th, 2020. My name is Amy Blake, and Justice Massing and Justice Neyman are also sitting today. The three of us comprise your panel for the day. We will be hearing 6 cases. After the first 3, we will take a short break. For those of you that may be watching on YouTube, please do not sign out. You will be able to continue to watch us. There'll just be a short break in between. I think if we don't have any other preliminary matters, we can call the first case, which is Commonwealth versus Michael DELEON, docket number 19P634. Attorney Katz, good morning.
Good morning, Your Honors. Daniel Katz for the defendant appellant. As the court reviews this case, I would like you to keep in mind several principles. One, from Commonwealth v. Kozik, that the Supreme Judicial Court declared a little over 30 years ago, the prosecutor, as representative of the government, must hold him or herself to a consistently high and proper standard. Now, 85 years ago, the United States Supreme Court in Berger v. US, then reiterated about 17 years ago in Commonwealth v. McCoy, while the prosecutor may strike hard blows, she is not at liberty to strike foul ones. And now I'd like to turn to those foul ones that the prosecutor in this case struck in her closing argument.
I hate to jump in, but is using the words impressive and eloquent foul language?
It is in this case in terms of injecting the personal opinion of the prosecutor into the jury's mind. The courts, the SJC, and the appeals court have specifically said that statements by the prosecutor, such as "this witness is the best," are improper statements, meaning it's prosecutorial misconduct, because it interjects the prosecutor's personal belief or hints at some prior knowledge that the jury is not aware. So foul in the sense of an improper remark or statement in a closing argument that, first off, is not even based in the evidence, and second, is improper because it interjects the personal belief in the credibility, and in this case, the Commonwealth's only expert witness and the one who gave testimony as an expert that this, the white powdery substance, in her opinion, was cocaine. So the praise, clearly, if you look at the cases that I cited in terms of saying that, oh, this witness is the best I've ever seen in the courtroom, it is improper.
So I think, perhaps these, this is a personal opinion of what she thought testimony, but she's not comparing it to any other knowledge she has. She's referring to the testimony of the expert. She impressively recited the procedures. I couldn't say those things so eloquently. She's not saying it's better than anybody I've ever seen. And in fact, she's actually relying on what the jurors also saw. I mean, couldn't that be categorized as an inference from the evidence?
Absolutely not, Your Honor. It is it's an interjection of a personal belief. There's no evidence that this witness was a great orator. I mean, there's nothing in the facts from which the prosecutor can say, oh, look at all these awards this expert had won in terms of her speaking skills.
Mr.
It's
Katz, so
clearly,
I see it different than that. I agree with you. There's nothing about awards and things like that. As I read it, you just had all this, I guess you would say, sort of complicated chemical analysis that those without a chemistry or biology degree might find it difficult to explain and analyze. And I see the Commonwealth is saying, look, I'm not even going to try to screw up what it is that she said, because I can't say it that way. That this is technical stuff. You should, what she said is what controls here, not what I say, and obviously what the memory of the jurors is. I see this as sort of saying, I can't say it like she said it, so, think about the way she said it. Why is that foul?
okay, Your Honor, if I may say, what you just said, you said, I can't say it the way she said it.
Right.
Therefore, Your Honor, okay, jurors, listen to what she has said. But what you didn't say, and what this prosecutor did say, is, whoa, hey, jury, look how eloquent and how impressive she is. Those two words, or similar words, Your Honor, were missing from what you just said. And I think I would, quite frankly, have a harder time if what you said is what she said. Because what you said was not interjecting your, I believe, personal belief in the eloquence, the impressiveness, the majesty, or the intellectual ability of what she said. What you said was actually just saying, look, listen to what she said. To me, I think, based on the case law, that would have been okay. But Your Honor, that is not what happened here. I don't see how that's not what happened here, because what the prosecutor did was clearly, and you actually see that the judge right after, I don't want to say scolded, that may be a strong word, but definitely told the prosecutor, look, I wrote this down, you said impressively and eloquently, and you, prosecutor, coming from the judge, you have to be careful in choosing your words. And one thing that I have found from the cases that specifically say, well, you can't just say, this is the best I've ever seen in the courtroom, that words, specific words, what they mean something. They have to mean something, because clearly, and I know the cases say there's no bright line and it's difficult, but I think the fact that she, the prosecutor, is putting quite strong adjectives in describing the testimony to the jurors is giving, and I know this isn't my word, the imprimatur of the government giving the stamp of approval that this witness should be believed because A, look, jury, look how eloquent and how impressive she was.
Can we move to the next? Can we move to the next one? We're running out of time here.
I'm sorry.
Sorry.
I just have two questions with regard to this issue, if you don't mind, Justice Massing.
Go ahead.
Actually, why don't you ask your question, then I'll go back to it. That's fine.
I was going to. I mean, in the brief, Mr. Katz says that another thing that the prosecutor did was told the jury that the judge had designated the troopers as experts on drug identification. I don't see that in the argument. Can you tell me where that is?
Sorry, could you repeat that, Your Honor?
You say in your brief that the prosecutor told the jury that the judge had designated the troopers as experts.
Oh, okay.
Where does it say that?
The other transgression that I believe the prosecutor made was when she said that all the years and years of experience of the troopers also gave their expert opinion. And
oh, wait, I still don't see the word expert. All I see is, so the state troopers with years and years of experience believe that the substance is cocaine based on their training and experience. That, I guess that refers to expert words, but she never says they're experts. She never says the judge designated them expert. Is that correct?
It doesn't say the word designate, but I think those first sentences that you read tied into equating what they said at the last sentence of that speech to the expert, to Christine Tyson. I think I would implore that that is essentially saying, look, they are expert witnesses. And not only there was only one trooper actually who gave an opinion, and his opinion was not, this is in fact cocaine, or I did field testing, which he didn't. It was, I believed the white powder to be cocaine. And the other troopers who were involved, Sergeant Reed and Foster, did not offer any opinion. And so what that prosecutor has said misled the jury.
Right.
And
The judge did specifically correct that one, right?
He did say, yes, he did say that, and I don't think it was as clear as I think it should have been, but the judge did say that the only witness, and it's not clear, quite frankly, from the judge's curative instruction, whether the judge was saying the only witness who gave an opinion testimony on the identity of the white powdery substance, or the only expert testimony. So it's not completely clear to me if the curative instruction covered that. But what the curative instruction did not cover was the what I believe was a transgression in terms of impressive and eloquent. And I understand that the objection was lodged. There was a curative instruction. So perhaps under Beaudry, I have to go for a higher hurdle of substantial risk of a miscarriage of justice, because there was some acquiescence by defense counsel in the instruction, even though the instruction did not specifically address the transgression of the praising of Christine Tyson. But even under that, sorry,
Attorney Katz, you just started to address one of my two questions, which was, what is the actual standard of review for the vouching issue? Because the trial transcript, volume 2, page 92, the judge said, I'm going to give, are there any requests for a particular instruction, corrective instruction? The attorney said, defense counsel said, I mean, using the instruction that closing arguments are not evidence. The judge then went on and instructed the jury, I believe, at least 5 or 6 times, both that closings are not evidence and you are the sole finders of fact, and that what counsel says does not constitute evidence. Then the judge asked, are there any objections? And defense counsel said no.
That's why, Your Honor,
isn't the correct standard of review for the vouching issue in closing argument substantial risk?
Yes, I now believe that, Your Honor, even though there was, sorry.
So with that in mind, can you cite a case, published case from the appeals court or the SJC, where an error like this, the use of 2 adverbs, eloquently and impressively, in the context of closing argument, was held to constitute a substantial risk of a miscarriage of justice?
Well, if I would implore Your Honor that I'm not just relying on the improper use of the superlatives, I'm also relying on the other transgressions in terms of the officer's testimony.
The officer's testimony.
And saying, quite frankly, Your Honor, implying quite strongly, I believe, Your Honor, that it wasn't just the expert who gave an opinion, there were these officers. And yet it's clear in the transcript that actually only one, that's Trooper DeFossis, who was involved in the transaction, who said, I believed it to be cocaine. The other 2 did not. And if you look clearly, and I know you will, at what the prosecutor said, she specifically, expressly said that all officers. So to me, and I'm asking for you to look at the cumulative effect, and I agree with you, I think it all does now fall under the substantial risk of miscarriage of justice. But even with that, I think the defendant, we can overcome that hurdle. Because let's look at the strength of the Commonwealth's case, right? The 4 factors that you look at: strength of the Commonwealth's case, nature of the errors, significance of the errors, and possibility that the absence of an objection was the result of some trial strategy. And also, I would just like to call your attention, in the beginning of the transcript, there was an exchange between the prosecutor and DeFossis about the phone call that happened. And in the phone call, the trooper mentions, oh yeah, well, he sounded like, and I'm slightly paraphrasing, but he did say a drug dealer. Now that was objected to but then it wasn't, and the objection was sustained, but it wasn't struck. And I know that there wasn't any further inquiry or requests made by defense counsel. But I would like you to add that in terms of looking at the cumulative effect. Right at the beginning of the trial, you have prejudice defining this, the voice, and he identifies the defendant as the voice he heard twice, as a drug dealer. Now, fast forward to the closing argument, you have only Christine Tyson saying, and her, even with her, comes out the fact of the chain of custody. And I implore your honors to remember, the drugs were, the white powdery substance, excuse me, was delivered June of 2013. It was not analyzed by Ms. Sugrum until November, I believe, of 2014. So you have a chain of custody problem. There was that narcotics form inventory form, because Ms. Sugrum, the analyst who did the testing, recognized that the seal was not signed and it wasn't initialed. And I know, of course, you'll look at my time is
Yes,
up.
let me see if either of my colleagues have any additional questions.
Yeah.
Okay, I guess we're going to have to leave it there. Thank you.
Thank you.
Attorney Tretyakov.
Thank you, Your Honor. Good morning, Your Honor. May it please the court. My name is Konstantin Tretyakov from the Middlesex County District Attorney's Office. I represent the Commonwealth. In this case, the prosecutor's closing argument was proper and in any event did not result in unfair prejudice or a substantial risk of a miscarriage of justice to the defendant. With respect to the prosecutor's remarks that the expert impressively and eloquently recited the procedures, the testing procedures and protocols used in the lab, I think it is best understood as the prosecutor's reluctance to repeat all the highly technical jargon that the witness for the Commonwealth used in her testimony. Now, admittedly, that was not, so to speak, the most eloquent way to put that before the jury. But even assuming, for the sake of argument, that they understood it literally, all the jurors were present in that courtroom. Any juror without any specialized training and experience was able to decide for him or herself whether the expert testimony was eloquent or whether it was impressive.
Mr. Tretyakov, let me just stop you right there.
Yes, Your Honor.
Should a witness be believed because they are eloquent?
Your Honor, that is for the jury to decide based on. I would not speculate as to what weight or what credibility a juror would assign to the testimony of a specific witness. So,
should a witness be amazingly eloquent and still lack credibility?
conceivably, yes, Your Honor.
Conceivably, or yes?
It could be, Your Honor. Again, I would be very hesitant to speak as to the precise process that any given juror goes through in his or her deliberations about the case. But even
Can a witness be, I'm sorry to interrupt you, but can a witness be inarticulate and still be very credible?
it could be the case, Your Honor, yes.
So it seems to me that eloquence and impressiveness of one's speaking really is not a factor in terms of whether or not to believe that witness. Do you agree?
Your Honor, even assuming for the sake of argument that that's the case, in this case, and again, analyzing that in the context of the entire closing argument and in the context of the entire trial, the defense counsel requested, obtained, and was satisfying with the curative instruction that the judge gave, which was to say that the closing arguments are not evidence, which makes sense because the identification of the controlled substance as cocaine or the chain of custody were not really the issues of trial in terms of if the court is evaluating the prejudice or the substantial risk of a miscarriage of justice. The defense at this trial and the defense counsel admitted to the court as much when he was filing a motion for required finding of not guilty, that is volume 2, page 70 of the trial transcript, was to argue the identification of the defendant. That was the crux of the defense. And in that respect, it is very logical that the only curative instruction that counsel has requested with respect to cocaine and with respect to the troopers testifying that it was cocaine was that the closing argument was not evidence, and the judge repeated that instruction to the jury 3 times. So those forceful, repeated, and timely instructions, which the defense was completely satisfied with, I think completely mitigated any, however slight, risk of prejudice, even assuming for the sake of argument that the prosecutor's remark better be left unsaid. As to the trooper opining that the substance was cocaine, again, there is no indication that the prosecutor told the jury that the judge designated the troopers as expert witnesses. That is not what the Commonwealth said. The trooper did testify based on his training and experience, more than 900 undercover purchases, thousands of drug investigations, without any objection by the defendant during trial, that the substance that the defendant gave to him was in fact cocaine. And the prosecutor marshaled that evidence in her closing argument, saying that Trooper DeFosses believed that the substance is cocaine. That can be found on page 88 of the trial transcript. And yes, after that, she inadvertently used the plurals of the troopers instead of the singulars, which the defendant did not even object to after the closing argument. But then again, even assuming that this was an inadvertent misrepresentation to the jury, a slip of the tongue, the forceful and repeated curative instructions of the judge would have cured, and did in fact cure, any improper prejudice that could have resulted to that. But the judge did not stop there. In addition to the instruction specifically requested by the defendant, she also instructed the jury that the only expert witness who testified in this case was Christine Tyson. That's page 97 of volume 2. That the credibility of the police officers is to be weighed exactly in the same way as the credibility of the civilian witnesses. That's page 102 of the trial transcript. And the credibility of an expert is to be weighed in exactly the same way. She said, the expert witnesses do not decide cases, the juries decide cases. That page is 102, 103 of the closing argument. So on this record, Your Honor, even assuming, again, for the sake of argument, that some of the portions of the prosecutor's closing argument better be left unsaid, the curative instructions cured any prejudice, however unlikely that the defendant might have faced because of that. I would like now to, unless the court has questions about this issue, I would like to briefly address the second issue that my brother raises, the confrontation clause. According to the well-established case law, the confrontation clause is not violated if the expert can be meaningfully cross-examined about the reliability of the data and can testify on his opinion as to, in this case, whether the testing material is indeed cocaine, based on the materials that would have been admissible at trial. Both of these criteria have been satisfied in this case.
Well, can I ask, how could the defense counsel meaningfully cross-examine the substitute expert about stuff that happened when the substitute expert wasn't around?
Your Honor, the substitute expert was scientific scientist 3 at the laboratory. That's a supervising position. So she was able to testify about the testing protocols, the handling of the material, about the change of custody. And when my brother...
But she was not involved, like she wasn't the confirming chemist or anything on this particular one, was she?
No, Your Honor, she was not. But under Commonwealth against Greidener, that would not be a problem, because in that case, the director of, I believe, SALISBURY laboratory, who also did not participate in the testing of the DNA of the defendant, also testified extensively about the testing protocols, and the SJC said that that testimony was proper. And in this case, the defense counsel actually was able to cross-examine very skillfully, I would say, the Commonwealth witness about the about the degree of error in the testing protocols, about whether or not she was around during those protocols, and then was able to use that in his closing argument. That would be found on page 85 of the second volume of the trial transcript. So when my brother is citing Commonwealth against Jones, that quote, when the only answer that the witness is able to give on cross-examination is, I don't know, that's not proper under the confrontation clause. Well, if you look at the cross-examination of the defense of the Commonwealth witness by defense counsel, she did not say, I don't know. She always was able to answer all the questions posed by the defense counsel to her. So on this record, Your Honor, the Commonwealth submits that there is no violation of the confrontation clause and no violation of the defendant's constitutional rights.
Tretyakov, your Mr. Katz, with regard to the Grady case, points to some language, and it's at page 724 of that case, where the substitute expert's opinion was formed on the basis of tests conducted by the non-testifying analyst, which and I'm quoting from the case now, which the substitute chemist, quote, reviewed at the time the tests were conducted, as well as prior to testifying at trial, end quote. And Mr. Katz suggests that that language, that the substitute chemist reviewed the tests, reviewed the information at the time the tests were conducted, separate that case from the present case. Can you explain why that is correct or incorrect?
I believe that is incorrect, Your Honor. I think it definitely doesn't hurt when the expert witness who is testifying at trial can contemporaneously review the testing conducted at the laboratory, but that is not a requirement. For example, there are cases where we have substitute chemists who testify on the based on the materials that were produced in chemical labs in other states. And by virtue of that, the chemists in Commonwealth are not able to do that. And case law does not contain that requirement. Again, I would draw the attention of the court to Commonwealth against Greinader, where there is no indication that the director of the lab who testified at trial was doing this contemporaneous testing, and the Supreme Judicial Court said it was proper because, again, the real test is whether the expert can be really meaningfully cross-examined on the reliability of the data, which was the case here. And
sorry to interrupt, but so you're saying that the language in Grady, quote, reviewed at the time the tests were conducted, end quote, is simply dicta?
I would say, Your Honor, that it is not a constitutional requirement under the Confrontation Clause. Again, that obviously doesn't hurt when the testing is conducted simultaneously. That is, to put it colloquially, that is a good thing, Your Honor. But that I would not say that that is something that, absent which, the Confrontation Clause is violated. Again,
it's helpful, but it's not a constitutional prerequisite.
Correct, Your Honor. For all these reasons, the judgment of the Superior Court should be affirmed. Unless the court has further questions, the Commonwealth rests on its brief.
Justice Massey, Justice Neyman?
Nothing further.
Seeing none, we will take the matter under advisement. Counsel, thank you both for excellent arguments this morning. Take good care.
Thank you, Your Honor. Thank you.
Transcript that would suggest that it was a stipulated fact or element.
I don't think it was stipulated in the sense of a written stipulation. It was simply uncontested. It was testified to by all three witnesses. And on page 115 of the transcript, defense counsel says, no, Your Honor, it's not a contested issue. Where it's not a contested issue, it simply cannot give rise to a substantial risk of miscarriage of justice. May I move on to the sentencing issue? No further questions on the instruction?
Well, I can't guarantee that, but not at this moment.
No, oh, very good. In my brief, I did encourage this court to remand. Upon further review of Rule 29A2, I think that the appropriate course, the request from the Commonwealth, is actually that the court affirm the conviction because there were no errors in the conviction itself. And then after issuance of the rescript, the defendant can move under 29A2 to revise his sentence with regard to the unjust additional 5 days based on his immigration status. And as I argue in my brief, the sentence should be modified because from the language of the judge, what he stated was that he was holding the defendant for an additional 5 days to give ICE an opportunity to pick him up, which under Lunn is a new purpose. I understand that it was within the range of a lawful sentence, but the purpose of those 5 days was to let ICE pick him up, and I would suggest that the sentence was illegal under Lunn.
So I just want to understand procedurally, do you think we have to address the sentence?
No. I don't think you have to address it. I think it may provide helpful guidance to the sentencing judge, but I think that this court can remand on the merits of the conviction because there was no error creating a substantial risk of miscarriage of justice on the jury instruction. Once the conviction is affirmed and the rescript issues, then 29A2, the portion of that rule that says within 60 days of the issuance of a rescript, the judge may revise or revoke such sentence if it appears justice may not have been done. So
sorry to interrupt, is the Commonwealth representing it will not be opposing such a motion?
That's correct, with regard to the 5 days. Are there any further questions?
I do not see any.
Thank you. The Commonwealth rests on its brief.
Excellent arguments from both of you. Thank you so much.
May I proceed?
Just waiting to get the okay from Matt.
And then Judge Blake will call the case.
The case is now being live streamed.
Thank you. Our next case is Commonwealth versus Anthony ORTIZ-CORREA, docket number 19P 719. Attorney Naras, when you're ready.
Thank you. May it please the court. This case, I believe, is fairly simple and straightforward. I don't think there's even much dispute about the facts of the case. Very briefly, for the purpose of the malicious destruction issue, which I'd like to start with, I'll just describe the facts as I believe they are laid out. My client, Mr. Ortiz, was at the Burlington Mall coat factory in Holyoke. He was with his wife and some others. There was another group who was also there. That included Miss Rosa Robles and Joel Valentine and some others. The two groups met up. There was a very heated argument inside the coat factory, at which point I think a justifiable reading of the transcript is my client became enraged and began yelling and slapping the floor. And that stemmed from the fact that the two women were having an argument. Mr. Valentine began laughing at them, and it appears that Mr. Ortiz, my client, took offense to that. And
let me then jump in right there, because I
sure.
think we're all familiar with the facts. And I guess the question is, what do we make of the knife and the window? And the Commonwealth relies on the Redmond case in opposition to your argument about hostility. Are you familiar with Redmond?
Yes, actually, I believe I rely on the Redmond case as well in my brief.
So let me ask you about this particular quote at page 4 of Redmond, which is quoting Semino. Malice does not require the defendant know the identity of the owner of the property damaged. The animus need not have so personalized an object.
Yes, in the Commonwealth, actually, I believe in its brief suggests that I kind of cut my quote off and Redmond quickly on that. But actually, if you read further down, the very next paragraph, they talk about what is required. In the quote that Redmond continues on, it indicates that the malice still must be by design hostile to the owner, whoever that may be. I believe the Commonwealth's argument, I believe the Commonwealth's just misreading the cases. I believe all the cases say the same thing. And I do agree with the Commonwealth that the Commonwealth does not need to prove that the defendant knew who the owner of the vehicle was to commit the malice against the owner of the vehicle. However, the malice still needs to be directed toward the owner of the vehicle. Perfect example of that is, obviously, if you're walking down the street and you start kicking in car windows or keying cars or spray painting cars, you're acting with malice towards the owner of those vehicles. You have no idea who those owners are, but you still are acting with malice towards those owners. And I think that's what Redmond says. And in Commonwealth versus Morris, which I also cite in my brief, cites Redmond directly and reiterates the fact that the malice needs to be towards the owner, even if the owner is unknown, but it still needs to be towards the owner, not towards a third party. And
So
I think
under the Lattimore standard, And in light of the prior dispute at the mall, where your client was upset that he was being laughed at, including by, I believe, Ms. Robles, and that she's in the car and he's punching the window and she testifies he's angry, he's swearing at her, or he's using bad words, was her testimony. And he strikes the window at her 2 times and smashes, or at least, damages the window. How does that not meet the definition of malice, in particular hostility, which is what is required?
Right. And I think, and that's why I wanted to just get into a little bit of the facts. So I think what occurred was, and I think the Commonwealth actually concedes this point in its brief at page 25 to 26, is that the anger was directed at Mr. Valentine. In the you actually see this play out in the facts, where he comes out, Ortiz, and pulls a knife out. And Miss Robles, actually, the victim, holds him back. He doesn't try to attack her. He doesn't try to stab her. He's going after Mr. Valentine the whole time. They break up. He goes back in the store. He comes back to the car. Mr. Valentine's sitting in the car. He goes directly to the window and starts stabbing at the window, which the prosecutor in closing argument highlights. That's the theory of defense. The malice is towards Mr. Valentine. I believe the quote is, he's trying to get at him. He's trying to get Mr. Valentine. He's trying to stab him. Which means that he's the malice he's using when he's breaking. I don't even want to say malice he's using. The reason why he's trying to break the window is to get at Mr. Valentine, not to wreck up the car. And I think
that's one interpretation. He could also be doing it to threaten and scare Ms. Robles.
But I don't think there was any evidence of that. And I don't think the Commonwealth argued that at trial. And I don't believe that the Commonwealth is even arguing that on appeal. I think they've conceded in their brief that the trying to break the window was to get at Mr. Valentine. And also they state that the malice was towards Mr. Valentine. I don't think they've ever argued that the malice was towards Ms. Robles.
But we can affirm, if we were to affirm, on any ground supported by the record, right?
I don't think that there was anything in the record that disputes the Commonwealth's position or their argument at trial. And I think it's important.
What about the judge finding that I'm not guilty on the assault against Valentine?
Well, Mr. Valentine just denied that he was being attacked. He just flat out said it didn't occur. I don't think the judge had any ability to find him guilty on that based on the facts. I mean, possibly. It
seems to me that the judge, rather than thinking that, the judge actually specifically disbelieved that he's trying to get at Valentine through the window. And I think in addition to where the malice is directed, doesn't your theory of the evidence require that it's a means to an end? And isn't kind of unlikely if you're trying to get somebody, you go through the window as opposed to through the opening a door?
Well, the only evidence I think that was provided for the reason for trying to break the window was to get into the car at Mr. Valentine. If that is disbelieved in its entirety, then the evidence is clearly insufficient for a conviction on the malice prong, because that's the only evidence the Commonwealth put forward for the reason for trying to break the window. And I think that's a fair reading from the record. And I would also say, Your Honor brings up an important point. I think the malice idea of it has to be directed at the owner of the vehicle is also the other side of the same coin when it comes to what the reason for trying to break the window was. It wasn't to wreck up the car. It was a byproduct of a completely, wholly different crime. And that's Redmond. That's what Redmond talks about. Redmond is about breaking into a house to steal computer parts, and breaking the window, disabling the alarm system was just a byproduct of that. The Commonwealth actually cites a case that I believe actually illustrates this point, Commonwealth versus Wynn, in which there was a home invasion and the people went in and really wrecked up the house for no reason associated with the home invasion other than cruelty. in the court in that case really says there is a line that he crossed. So it's not that there's no line for malice. It's just that in the Wynn case, they crossed the line and they started breaking doors. They while inside for no reason. They started scattering property around for no reason.
And
But
so
they
your view
reiterated
here is that
Oh, I'm sorry.
at best it's wanton and that's not a lesser included.
That's correct, Your Honor. I think that is clear. And if you look at the cases, Commonwealth versus Morris, Commonwealth versus Amaran, they're both motor vehicle cases involving fights where the car gets broken up during a fight.
If instead of stabbing the window, there had been this altercation, verbal altercation at the mall, and Robles and Valentine are leaving the mall in the car, and your guy picks up a decent sized rock, throws it and hits the windshield in the back, and it splatters the windshield. What's that?
That's malicious destruction of property. And I think their convictions should stand in that situation.
And so tell me what the legal distinction is between the facts in this case and the hypothetical that I just gave you.
I believe in your hypothetical, the malice, I think if you think about it, like the malice is directed at the object. So, and then the owner by extension. So if you're breaking the car window, you're just mad at the people in the car. You're mad at the owner. You're breaking the window for hostility, for revenge, for cruelty. Whereas when you try to break the window to commit a crime, a separate and distinct crime, then the reason for breaking the window isn't by design for hostility, cruelty, or revenge. By design, it is to stab Mr. Valentin, which obviously is not a good thing. It's a crime, but it's not the crime of malicious destruction of property.
If there wasn't a second incident at the pizza shop later on, so we didn't have the ADWs, is your argument any different?
No.
So he stabs the window, it breaks, they leave, and that's the end of the conflict between the two groups. Is your client guilty of malicious destruction?
No, he would certainly be guilty of wanton destruction if the Commonwealth had chose to charge him with that crime, but they didn't. They went with malicious destruction of a motor vehicle, and the malice just wasn't there. That, I believe, that crime, alleged crime, ends at the moment they drive away. I think the incident that occurred later shed some additional light on the fact that Mr. Ortiz was focused entirely on Mr. Valentin, because when he shows up, he's still hot. He's still looking for Mr. Valentine to continue the altercation, which is, flashing the gun and all those sort of things. But he again, it just shows that he is not going after Ms. Robles. It's Mr. Valentin. But I don't think that necessarily matters all that much, because I do believe, or if it does matter, it matters in favor of Mr. Ortiz, the defendant, because all it does is show more evidence that his animus was toward Mr. Valentine, and not the car. He wasn't just trying to break up the car because he was mad at the Robles group. He was trying to break the window to commit a crime, not by design, just out of cruelty or hostility towards the owner of the car. And I don't think it matters if he knew it was Robles' car. I don't think it matters if he knew it was someone else's in their car. I agree with the Commonwealth on that point. But the malice needs to be directed at the owner, and the malice also needs to be malice and not just the byproduct of a wholly distinct crime. And I think that's what Redmond talks about, Morris talks about, Amaran talks about, the Commonwealth's case, Commonwealth versus Wynn talks about. So I don't think the Commonwealth—
In light of the time, can I just ask you briefly on the EDW? Nobody argued this, but I'm curious what you think about the concept of transferred intent with respect to the ADW and the gun.
Well, Mr. Valentine wasn't even present at that point. I don't believe that there was a transferred intent argument that could be made at the Commonwealth at that point. It was, I think the crime would have been a threat against Mr. Valentine by showing the gun to Ms. Robles. I mean, he was just threatening Mr. Valentine. I think it's clear that he was not putting her or did not intend, which I think is what the Commonwealth needs to prove, that he was putting her in a fear of an imminent battery. And Mr. Valentine wasn't present, so I don't think you could get an imminent battery on Mr. Valentine. It has to be something, more than a threat to someone who's not present for it to rise to the level of assault and battery. Assault rather, on an attempted battery, because there was no. I'm sorry. Let me say that it wasn't an attempted battery. It was a threatened battery. That's the allegation, but it wasn't imminent towards Mr. Valentine, and it wasn't the intent to threaten Miss Robles. So I don't think there was a assault and battery with a dangerous weapon on Miss Robles at that point. I believe it was a threat, the crime of threats towards Mr. Valentine.
And yet he was holding a dangerous weapon and swearing at her, showing her the knife, and breaking the glass with the knife, stabbing it toward her. If that's not a threatened battery, I'm having difficulty seeing what is.
Well, I believe the assault with a dangerous weapon is what occurred later on at the liquor store when he showed her the gun. I think that was the Commonwealth's case, not anything that occurred at the mall. So I don't think that would come into the facts. And I think when they were at the liquor store, it's clearly bad behavior, but I don't think it's the crime that Mr. Ortiz got convicted for.
And there were no instructions because this was jury waived, correct? So we don't know specifically, or did the judge differentiate that conduct in his verdict? Remind me.
I believe
I can take a look at it right now.
Yeah, I'm not sure, but the judge did make pretty detailed findings on the record.
Yes. Okay. Thank you.
Thank you, Your Honor.
Thank you. Attorney Carl Flores, when you're ready.
Thank you. Thank you, Your Honor, and may it please the court. Joseph Colliflores for the Commonwealth Hand District Attorney's Office. When we're looking at the malicious damage to a motor vehicle case, we're talking primarily in the defense counsel's argument about Commonwealth v. Redmond, which also cites the Commonwealth v. Wynn. Now, the full quote after on page 5 of the Redmond case talks about distinguishing between discrete acts of criminal enterprise, such as the theft of computers in Commonwealth versus Wynn. Now, the defendant also cites the Commonwealth v. Morris M, a juvenile case, and I think that's a case that's worth discussing in analysis compared to the case at hand. When we're looking at Commonwealth v. Morris, a juvenile is in a motor vehicle and someone breaks into the motor or gains access to the motor vehicle to have a fight with a juvenile. The juvenile then begins swinging some sort of makeshift weapon and in the process breaks a window. That is completely distinguishable as far as causation of the break in the window, because that was ancillary to the fight that was occurring in the motor vehicle. When we're looking at the case before us, we have this fight that started in the Holyoke Mall, proceeded out to the parking lot where the defendant attempted to get in the vehicle. He had not begun some other kind of criminal conduct at the moment that he begins attempting access. He tries the door handle, he tries his fist twice, and ultimately tries the knife twice. It's unclear if it's either a stabbing, this motion, or this motion, but regardless of the motion, he is taking a knife to that window and ultimately damages it. There's no requirement that he know who owns the vehicle, but rather only that he's acting out of some sort of malice to somebody. And that's borne out in Commonwealth v. Redmond, Commonwealth v. Chambers, which is by analogy because it's talking about General Laws 266, Section 127, which is very similar to the case for malicious damage of a motor vehicle. In the light most favorable to the Commonwealth, it's absolutely clear that the defendant, when he exited the mall and approached the vehicle and went after that door, that he was acting in animosity because Mr. Valentine, earlier in the mall, when he asked, "What is this about?" Ms. Robles informed him, and he then smiled and laughed, which set the defendant off into a rage. Such a rage that he was yelling at them, that he was slapping the ground with his hands, and that he followed them out into the parking lot. There are no questions.
About, it's a somewhat unrelated issue, but if we were to agree with your brother's arguments, I know that as part of the underlying case, the Commonwealth filed a null pros on the habitual offender because it was a stipulation to sentence. If it were to be remanded, would the habitual offender be back on the table?
Your Honor, I haven't particularly contemplated that, but my initial thought would that be that agreement would be null and void because it was set on the facts that were coming out of trial. And I'm not sure that the defendant himself would want to be held to that if you were remanded for a further trial. So my initial thought is no, but I have not given that much legal thought.
And the hypothetical that I gave your brother about rather than there being an altercation later on at the pizza shop when Robles and Valentine get in the car, they're driving away, and he throws a rock that smashes the window. Your brother says that's different than what happened here. I'm going to assume that you don't think it's different, and if not, tell me why.
Well, so I agree that that is also malicious damage of a motor vehicle. He would be acting out of rage when he picks up whatever that item is and throws it at the motor vehicle. It's pretty much the same facts without an additional knowledge that he's at that very moment angry at Mr. Valentine. Now, we can infer, if we keep the earlier fight within the Holyoke Mall, we can infer an anger only at Mr. Valentine because that's who he was fighting with. Miss Robles and the other female were trying to stop from whatever was going on. So if the only factual change in this hypothetical is that instead of physically punching or stabbing at the window, instead he throws a Hail Mary with a rock and it breaks the window, it's still malicious damage of a motor vehicle. All the intent is there, the anger that is there, the base elements of malicious damage to a motor vehicle are present.
And then do you agree with your brother that the doctrine of transferred intent would not apply as it relates to the assault with Ms. Robles?
I would agree. When we're looking at that distinct threat, it's more of a threat towards Ms. Robles, especially considering he doesn't enunciate any type of threat towards Mr. Valentine. From my reading of the evidence, he's kind of lifting up his shirt and he's reaching down into his waistband, but there's no moment to infer anything additional towards Mr. Valentine. The way it reads at trial is that he wants to know where Mr. Valentine is. Tell me where he is. Tell me where he is. I have a firearm. And the implicit threat there is if you do not tell me, I am going to use this firearm right now outside of this liquor store. So it wasn't a, tell Mr. Valentine I have a firearm here in my waistband. It was coupled very closely with the demands of knowing where Mr. Valentine is. So I don't think transferred intent is necessarily applicable or beneficiary to any legal analysis at that moment.
So the Commonwealth has to show that the defendant intended to put Ms. Robles in fear.
Yes. And when we're looking at the sufficiency of that ADW charge against Ms. Robles, it's very clear that the defendant, if we accept as true the evidence put forth as we must under Lattimore, that the defendant did, commit the assault. He intended it against Ms. Robles and that he was using a firearm. It was objectively menacing conduct intended to put Ms. Robles in fear. And indeed, her fear was already heightened from the early incident at the Holyoke Mall. That fear and placing of her in fear is clearly shown when she leaves the mall and goes to the police station and says, I want this known, but I don't want to press charges. And then she leaves and then the liquor store happens and then she goes back to the police station. It clearly shows that she was already in a heightened sense and that this final act by the defendant of brandishing the weapon in his waistband really pushed it over to that final moment. There she reported it.
But again, we have to be focusing on the defendant's intent, not the effect on her. Or do we focus on the intent on her to infer his intent? I
believe that when we're looking at it, we can look at her reaction. and it's coupled with the objectively menacing conduct intended to put a fear of immediately bodily harm, and that it was perceived. And clearly, Ms. Robles perceived that threat, which is inherent in the holding and manipulating of the firearm in his waistband.
Can I go back to a question on the malicious destruction? I've got another, we're doing a lot of hypotheticals today. I've got another one for you. Suppose that instead of running to the car, there's this fight the fight breaks out in the Burlington Coat Factory, and Mr. Valentine goes and hides in a dressing room. And the enraged defendant follows him with a knife and starts banging the knife on the dressing room door. Is that malicious destruction, or is that a means to a different end?
So in that particular circumstance, without some additional facts, which I think are different and differentiate, or they are differentiating in the present case, I would tend to think that is not malicious destruction, but I think an argument can be made for it. What's important to note in our case is that the defendant attempted to get in, punched it, and then withdrew the knife. So at that moment, he had been denied access, at least in two different means. The attempting to open the door by the door handle, which I think is foolish, punching a window. And then now he's got a knife to kind of keep attempting to break that window. His anger at being denied is growing right then and there. And so I think that's borne out in the evidence where he's outside the door and he's demanding, come on outside, fight me, fight me, fight me. Where in your hypothetical, where if Mr. Valentine retreats to a dressing room and behind one of the divider doors, without a fact that he's attempting to draw him out or anything like that, I think it's very different. If he immediately, upon seeing him go into the dressing room and puts a shoulder into it, I don't think the animosity would necessarily be there. That might be and I'm quoting from Redmond, the adventitious byproduct of a wholly discrete criminal enterprise. I think that's a closer case than here, where we have the defendant stalking outside of the Burlington Coat Factory, outside of the motor vehicle, in an enraged manner.
I don't have any questions for you, but I do want to inform Attorney Naris, trial transcript volume 2, page 10, does indeed clarify that the judge in his findings was speaking to the brandishing of the gun with respect to the assault dangerous weapon against Ms. Robles. So I stand corrected, Attorney Naris, and thank you for clarifying the record.
If the panel has no further questions, the Commonwealth will rest on its brief.
Seeing none, we will consider the matter submitted. Counsel, thank you both for excellent arguments.
Excellent on both sides.
Thank you, Your Honor.
The case is now being live streamed.
Our next case is Thomas DeFronzo and another versus the Salisbury Zoning Board of Appeals, docket number 2020P0022. Attorney Cornetto, when you are ready.
Thank you, Your Honor. May it please the court, my name is Chris Cornetta, and I represent Thomas and Susan DeFronzo in this case. The issue in this case is whether a 2012 building permit is the original building permit within the terms of Chapter 40A, Section 7, so as to allow for the residential use of this property.
Mr. Cornett, and I apologize for interrupting you so quickly, but I'll say that counsel for both parties wrote excellent briefs and did a tremendous job in the lower court. But that also begs a number of questions that I have. So I want to interrupt you just to resolve a couple of fundamental issues I have, if possible, okay?
Sure.
So the first, you just introduced your argument. The judge phrased it a little bit differently at summary judgment. He said this case hinges on whether the 2012 permit authorized use of the property as a multi-unit dwelling. Do you agree that that is another way of expressing the key issue in this case?
I think it's authorized the use of the property for residential purposes.
For residential purposes, okay. And if we determine, and believe me, this is a hypothetical, but if we determine that the 2012 building permit is not an original building permit within the meaning of Chapter 48, Section 7, are we obligated to affirm the grant of summary judgment?
Your Honor, if the original building permit is not I'm sorry, if the 2012 permit is not the original building permit, my argument to that would be looking at the entire history of this property for decades. This is not a situation where the town was just just ignoring what was going on at this property. The town was actively involved with this property for residential purposes. This kind of goes beyond the cases that deal with this issue, in that many times there is a permit that's applied for and the town has no idea what's going on at the property, and they're surprised afterwards to learn the level of activity. This case stands out because it's different.
You're speaking to the 2002 activities, the 2012 activities, and the other information in the record. I understand.
Certainly, including the 2012 actions by the Board of Health to go into the property and identify the apartments, identify the code issues. And at that point, Your Honor.
I know the facts very well. So let me get back to the 2012 permit then. The 2012 permit it stemmed from a corrective order, and it was a building permit to install second egresses in 2 of the units. Is that correct?
Yes, Your Honor.
Now, in Cape Resorts, the building permit there that was at issue stemmed from an improvement known as the Frolic Room. And there's language in that case where there was a preliminary layout accompanying the 1961 application. It indicated, I'm quoting from the case, very clearly that the space would include a bar, cocktail lounge, and entertainment facilities. And it included in the application a proposal to add a 21 by 43 foot or 21 by 43 feet to the side of the present hotel and remodel a portion of the interior. And that's Cape Resorts at page 217. And finally, Cape Resorts at page 213 stated, the SJC there noted a fundamental difference in the quality or character as well as the degree of use from the original hotel based on the changes pursuant to the special permits. Now, with that background in mind, can you tell me how our case with the permit seeking the installation of second egresses is similar to Cape Resorts?
Certainly, Your Honor. With regard to this case, the application itself and the accompanying documents themselves specifically say residential apartments, units. The correction order deals with residential apartments. I would respectfully submit to the court that the correction order is an accompanying document because it's part of the town's file. They know that they issued the order, and they know why the building permit came about because of that order. So the Cape Resorts case said the SJC in that case didn't need to decide the exact range of improvements to real property, which the words original building permit might apply. I quoted that directly from the case. And I think in this case, where an owner comes in and says, I'm submitting this application, I'm using the words residential apartments, I'm using the words units. There's no motel or hotel or rooms, suites, things that would be characteristic of a motel. And I don't know how more clear a homeowner can be or a property owner can be for residential property other than using words like residential and apartments and units. I think they very clearly articulated, similar in Cape Resorts, they outlined for the building department, this is what we're doing here. This is why we need this permit. In fact, because the town has ordered us to get this done. And on that basis, that's the similarity between Cape Resorts and this case, and how it's different from the Maurice case that the Superior Court relied upon.
Did the town ever issue a permit that expressly allowed the conversion of a commercial use to a multifamily residential use?
Not that we've seen. The only record that we have in this regard is the special permit. It would make sense that if you went and got a special permit, you also got a building permit to do what you're going to do, but we don't have that in the record, unfortunately. We do have the special permit, which the Zoning Board of Appeals from 2002 found that the conversion from 4 units to 3 in the back building allowed for residential purposes so that there could be residential financing. And this is sort of the history that plays into this case where the town, the Zoning Board of Appeals, not only knew about this, but they allowed a special permit based upon it. And so now fast forward 10 years later, I'm sorry, fast forward 16 or 17 years later, and all of a sudden the town is shocked to find out that residential activity is going on at the property. It just doesn't make any sense. They not just have known about this, like in those other cases, they've been actively involved in it.
Was the town saying they were shocked to learn that, or were they saying that, look, we told you to make changes to comply with the state sanitary code, but we never authorized use as a residential, for residential purposes?
Well,
And does that matter, is the follow-up to that question?
certainly. Interestingly enough, when you look at the original decision by the ZBA, they don't even make mention of the 2012 permit. They say that the only permit at issue is the 1984 permit. That means they either didn't know about it or they willfully ignored it. But in either event, you can't issue a decision that says, well, the only permit at issue is 1984, when that clearly is not the case. There's a 2012 permit here, which is what our case is relying upon in large part for establishing residential use. So I don't know what the ZBA did or didn't know about the 2012 permit. Unfortunately, as part of the case record in discovery, I wasn't allowed to ask about their thinking. That was specifically limited by the Superior Court.
And as I understand it, let's call it your alternative argument is that if we don't reverse, at a minimum, we should remand to the ZBA so that it can substantively address the 2012 permit and address whether or not it does constitute an original permit within the meaning of 48 Section 7. Is that correct?
Yes, Your Honor. I'd much rather prefer it go back to the ZBA so that they can find whether it's more detrimental or not to the neighborhood. But
That's the next step, right?
I guess I'll take what I can get. If that was the if
I'm just asking if that is, as I understand your brief, that is the alternative relief you are seeking. Is that correct or no?
No, it is, Your Honor. If at the end of the day, this doesn't go back to the ZBA with a determination as to whether it's more detrimental, then at the very least, I think the ZBA needs to address the 2012 permit and establish whether that permit is the quote unquote original building permit. It is nowhere in the ZBA decision.
So to get to what I'll call the detrimental prong of the statute, what did you need to demonstrate, and how did you do so below?
In the Superior Court, we demonstrated that the 2012 permit and the accompanying materials associated with this permit established clearly that there was residential use of this property. And we relied on the Town of Auburn case that establishes that you can look at the permit, the application, and the accompanying materials. The application clearly says residential apartments and units. The accompanying materials, the correction order, clearly instructs this owner and requires him under the penalty of criminal complaint to comply with residential requirements for these units. And looking at the correction order itself, it also identifies these units as quote unquote apartments. It doesn't say motel or rooms or suites. The only entity that ever uses the word motel after 1984 is the ZBA in the case in Superior Court. No one else has used that word in the entire history of this case because it is not a motel. It is a multi-unit apartment building, or as the town building inspector referred to it, the box. But in any event, the Superior Court relied on Maurice, and I'd be happy to distinguish that case from this one. And it's fairly easy to do. Maurice says, well, the owner in that property, who was operating a commercial trucking business in a residential area, applied for a fence and to erect a fence. And the application, the company materials just said non-residential trucks and equipment. And the court in that case said, well, this could be anything. Non-residential, there's any number of commercial uses that you could have. Trucks and equipment might mean anything. That's not applicable here because you can only have really one use for residential, and that's for housing and homes. Right. And so the idea that you're saying, well, it could be many uses just isn't applicable. And the Superior Court relied upon incidental they use the word incidental when describing the application itself. And that brings me back to my other point, which is, I don't know how clear someone making that application can possibly put it. If you say residential apartments, egress compliance, units, you're putting the building department on notice. This is residential. And in this case, the building department knows they're doing it because the Board of Health, which issued a corrections order requiring us to comply with state sanitary code.
Wouldn't that be required even if it was a motel? You got it when the egress would be necessary whatever the use is, right?
Well, I mean, obviously there would need to be an egress, but looking at the correction order, how it's phrased, it's quite clear that the Board of Health is looking at it from a residential perspective, i.e. these are apartments, these are units. These are not, they use words like living room and bedroom, things like that, I know they're just words, but I think in this context, they're critical to understanding the associated materials, which is the Board of Health saw this building as a multi-family apartment building. Didn't look at it as a motel, didn't look at it as a hotel at all. The documents that were in the Board of Health file that we identified also refer to it as a studio apartment and units and apartments, things that you wouldn't necessarily look at from a hotel or motel perspective. So even the Board of Health in issuing its order was not looking at this as a motel. They were looking at it as residential apartment buildings.
On a separate issue, how is it that you came in possession of the document that you say the town withheld in the health department file?
One of the litigants, Mr. DeFronzo, went back to the room where the Board of Health and the building department share a room, and got the Board of Health file, which according to his affidavit took the building inspector, who was there 1 minute to obtain. And when he went to the building department, went to the Board of Health file, identified the correction order. We produced, and as part of the record, a email from the Board of Health, Rosemary Deasy, to, I believe her name was Christina DeRuza, who works for the building department. She forwarded it to the building department with that correction order. So at that point in time, that email demonstrates that the building department had possession of that order. And we requested on 3 occasions records from the town. We specifically subpoenaed records from the building department, and that was not included amongst those records.
Going back to Cape Resorts, how would you say that the installation of the second egresses, or the seeking a permit to do so and obtaining a special permit to do so, I'm going to quote from the case, constitutes a similar, quote, fundamental difference in the quality or character, as well as the degree of the use of the property here?
The Cape Resorts case, in comparison to this case, noted that real property is not just the land itself. It's an improvement that results from not just land, but buildings as well. Real property
on a case-by-case basis. I understand that.
Okay. Real property is, and the fact that the building itself was improved by these egresses, you can't have, as the town argues, well, the egresses are protected by 48 Section 7, but nothing else. They're part of the building. It's not like the fence as in Maurice, where it's a separate structure outside of the building. It's all part of it at the end of the day. So when you look at this and you say, okay, these egresses give the authority for residential use, it's all part of that same building. It's all part of the same use. There's no real difference from what we see.
Can you answer me this legal question? Assuming you're right about the building permit being the 2012 correction order being the original permit, and the town didn't take any action within the statute of limitations, how does that make the use legal under Section 7? This, because it's not, Section 6 distinguishes between the original permit thing and then the 10-year authorization or implied legality of structures. So even if you're right about the 2012 permit, why does that apply to Section 6?
Because the Section 7 says if real property has been improved and used in accordance with the terms of the original building permit, they can't sustain an action afterwards.
But they're not. They're not sustaining action. You are seeking, a special permit.
Right, we're seeking a special permit, not because of the use, we're seeking a special permit because of the structure itself, because of the setbacks. So we're relying afterwards on the structural component, not the use component. We're seeking a special permit to alter or amend the structure because there's an issue of a 1.5 foot setback that needs to be addressed.
But is that, but doesn't have to be 10 years for that to work?
Well, the building has been in existence for well beyond 10 years. The record shows the building has been in existence for at least 20 years.
And so, but for that, then do you even need us to find that the 2012 special permit was authorized the use?
Well, we need the 2012 permit to establish the use. So otherwise, the town's argument the whole time has been the use is commercial. You can't do anything with this. You can't alter or amend the structure because the use itself is not even permitted, which ends up leaving this property in limbo.
I know that your time has expired, but I know that there were a lot of questions. Do Justice Massey or Justice Neyman, do you have any additional questions?
No.
No. Okay, we went about a minute over, so Attorney Stein, if you need the additional time, I'll happily give that to you. So as soon as you begin, the clock will start.
Thank you, Your Honor. Good morning. My name is Robin Stein. I represent the Town of Salisbury Zoning Board of Appeals. And I'd actually like to pick up my argument where the conversation just ended, which is I think that we're getting a little bit away from the underlying question in this case, which is not necessarily the 2012 building permit, but is that Chapter 40A, Section 6 only protects lawfully existing uses and structures. In this case, we have a use that does not lawfully exist. And so pursuant to Chapter 40A, Section 7, that use can never become lawful. And if that use can never become lawful, then a special permit allowing a structure to be raised and rebuilt to continue that unlawful use is not available. For example, had they obtained unlawful uses never become unlawful. That's what 40A Section 7 says about the 6 years. The town might not be able to bring enforcement against it, but it doesn't convert it to lawful the same way it does with a structure after 10 years. And if it's not lawful, it doesn't benefit from Chapter 48, Section 6 protections for pre-existing lawful uses and structures.
So
and
then as a
therefore,
practical matter, what would
Yes.
the DeFronzos had to have done? Or do you say they could never have got relief from the town to put in residential units?
well, there is, as zoning exists now, they would not have been able to do it. However, there is an opportunity to amend zoning, and the town actually has some motel language they could have attempted to take advantage of and to amend the bylaw. However, they permitted this use as a motel in 1984. At some point began using it as multifamily, and that's not a lawful use. And 48.7 is clear that it never becomes a lawful use. So if it
But
never
as a
becomes,
practical matter, why would the town prefer, I just don't understand this piece of the facts, a motel over a residence? I mean, at least with a residence, you have more consistency. You don't have the turnover that you would in a motel. So
Well,
what is the goal here?
I can't say that they are, I'm sorry, I can't say that they are preferring it, Your Honor. They're applying zoning to this property. Like I said, there could have been an opportunity to seek to amend the zoning. There is some language in the bylaw that we think they could have tried to use or expand in a zoning change. I don't believe they attempted that. I don't think the town is expressing any preference. It's merely applying its zoning bylaw. It's merely applying the law. And so you have a situation here where the DeFronzos would like to obtain a special permit to change a non-conforming structure so they can tear it down and rebuild it and use it for an unlawful use. And Chapter 48, Section 6 does not protect that unlawful use, and so they simply can't do that. And so I think
what you're stating that as a matter of black letter law. I understand the language of the statute, but is there also a case that says that exactly what you just said?
Well, we cited to the Bellotta case and to the Genta case in our papers, and Bellotta just
The
says,
land case.
yep. And so Bellotta is an SJC case, and that explains that 48.6 protects lawfully existing non-conforming uses and structures. And in the Genta case, similar to this case, the applicant actually obtained a special permit to make changes to a pre-existing non-conforming structure. And the land court said that special permit should not have been granted because their use is not lawful. And this is the exact.
That didn't involve the statute, it involved a bylaw with similar language, correct?
Yes, it's a similar nature of the 48.6 protections. And if you read the first paragraph of 48.6, the argument that I'm advancing only makes sense because that argument says that building permits apply, that zoning bylaws apply to new uses. And so in this case, had the DeFronzos obtained that special permit to alter the structure, they would not have been able to obtain a building permit to construct the structure, because when they came in to obtain the building permit, they would have been coming to obtain a building permit for a residential use that is not lawful. And even if they had the special permit for the structure, under 48.6, they can't get the building permit. It's the only reasonable reading of Chapter 48.6 in addition to the case law, which then leads us to the 2012 building permit, which is not insignificant, but I don't think is the ultimate factor in this case, because even if you were to say the 2012 building permit was an original building permit, which we say it's not, all that would mean is that the town could not take enforcement action. It would not entitle them to the special permit that they're seeking. But I do want to address that issue because I don't think there can be any legitimate question that the 2012 building permit was not an original building permit as the law has interpreted it, authorizing the use of the property for residential. I understand that it says residential. I would call the court's attention to the building permit clearance form that's on page 118 of volume 1 of the record, which clearly says that they're installing, it says install of 2 egress doors in existing residential apartments. When something is in an existing residential use, a subsequently issued building permit could not have been the original building permit authorizing that use because it was already in use. And this is a really important practical consideration, I think, for cities and towns when folks come in with permits. In Cape Resorts, what you saw was someone coming in to build an addition and explaining how they were going to use that addition. That triggers to the building inspector, this is new, it's a new use, I need to really look at it. Is this an allowed use? And that's different than when someone comes in and says, I want to make a structural change to an existing use. Had anybody come in and applied for a building permit to say, I have a motel, I want to make it residential, they likely would have triggered a level of investigation that didn't happen here because no one ever applied for that. They simply just started making the unlawful use. And I think it's important when we talk about the original building permit to understand why that's important. That's important because it's the first time that somebody in the building department, in the zoning office, has an opportunity to really look at that use and say, is this an allowed use? Folks come in all the time with building permits to make structural changes. They describe their existing use. They're taken at face value. They don't do an investigation. They wouldn't have the resources every time someone came in for a small structural building permit to go back and do a zoning analysis of every single property. It's not what cities and towns do under the law. It's not what they're expected to do. And it wouldn't be fair to put that burden on cities and towns. So in this case, well, yes, there's a lot of activity with this property. Some of it caused at the fault of the predecessor to the current owners who had health code violations, but nonetheless, the town takes the property at face value. So whether it's health code files, assessing files, a betterment, sewers, none of those folks are looking at zoning. They're saying, I have in front of me a property on residential use. I'm going to treat it and regulate it like instant residential use. And none of those actions, as many as they are, as cumulative they are, the period of time, none of those actions as a matter of law can convert an unlawful use to lawful. Even the zoning board or the building inspector not catching this sooner does not convert it to lawful. There's a large body of case law, and we've cited a lot of it on page 20 of our papers that talks in these estoppel terms, that mistakes need not be repeated, that boards don't have to grant subsequently because they granted relief in the future. You know, the simple fact in this case is that you have an unlawful use, that there's no building permit that ever issued allowing that use to start. I think it's notable that even the building permit that the DeFronzos are relying on talks in terms of 2 egress doors when they have 4 units. How can a building permit to put 2 egress doors in be read to mean we're authorizing a 4-unit multifamily use? I mean, there's no paper.
In fairness, that's not what your brother's saying. Your brother is saying that, you know, among the 2002 permit, the 2012 applications for special permits and granting of the special permits, that there was enough there, viewing all of the evidence. And Cape Resorts tells us to look at the big picture. There's enough there to where you had to have known that it was subject to residential use at that point and was being used as such. So when they apply for the 2012 special permit pursuant to the corrective order, you knew what you were doing. How do you respond to that?
Well, again, I think there's two things there. First of all, there's no evidence that the 2002 special permit materials were ever submitted with the 2012 permit. So I think that it would be appropriate to say that that's part of that package of papers that were before the building inspector in 2012. But the other issue is, even if the building inspector made a mistake in 2012 in issuing a building permit to put in egress doors, that does not make the use lawful. The law is clear. 48.7 is clear. Unlawful uses by operation of activity and behavior don't become lawful. You're either lawful under zoning or you're not. You're either lawful at the time that you used, you're not. And there's no estoppel to mistakes made by building inspectors, by zoning boards. Clearly, nobody caught this until more recently. However, none of that has legal effect.
Could you address your brother's contention that the ZBA did not address or did not consider the 2012 special permit?
Sure, I'd be happy to, and I addressed that in the lower court as well, is that because we say the 2012 special permit is irrelevant, there was no need for them to address it.
Right, assume it is relevant, so.
Well, with all due respect, it's difficult for me to do that, Your Honor, because he's critical of the board for not taking into consideration whether or not the 2012 was an original building permit in issuing them a special permit. But where our position is that your use is unlawful, and while even if they're right on the 2012 permit, it may or may not be immune from enforcement, you're never entitled to that special permit. There is absolutely no reason the board would have addressed it.
Okay,
it's not something that should have come into their analysis.
So you acknowledge, though, I understand you're saying why they did not, but you're acknowledging then that they did not consider the 2012 building permit.
I can't speak to that, Your Honor. I was not involved at the time. I don't know what they did or didn't consider.
Is there anything in the record that indicates that they considered the 2012 permit?
I'm not aware of that or not, Your Honor. But I can say it's very reasonable that they would not have, and it's sensible to me that they would not have, but I do not know. I don't think it's relevant.
The distinction in section 7 between barring further enforcement as opposed to making something illegal within the meaning of section 6.
Yes.
Is there that, I mean, I get that from the language. The language says structure and doesn't say use. Is there any case besides the footnote in Pyle from Judge Long that makes that distinction?
Yes, Your Honor, I believe. And also, if you look at paragraph 3 of 48 section 7, it's explicit that the structures become lawful. That was a new addition, I believe, in 2016.
Right. I mean, it says structure, not uses.
Yep. And that the purpose of that, Your Honor, was to make structures lawful and not uses. It was specifically added about 4 years ago for that very purpose.
And why the distinction?
I don't. Oh, yeah. I apologize, Your Honor. I can't speak for the legislature, but they was specifically added very recently for the specific purpose of helping out those structures, and they chose not to do that for use. And the statute couldn't be more clear that it's just structures that become lawful, uses do not.
I mean, is that maybe because you can see a structure from the outside, but you can't see a use from the outside?
Again, Your Honor, I'm not entirely familiar with the legislative intent, but I can tell you.
Can you make a guess?
I honestly, I really can't. I don't know. Perhaps it has something to do with, the cost associated with maintaining a structure versus the ability to change a use, but I really prefer not to guess. All I can say is 48.7 could not be more clear. Prior to 2016, everything was protected against enforcement, and now only structures are both protected against enforcement and after 10 years become lawful, but uses never become lawful.
Attorney Stein, can you briefly address the issue of withholding of documents?
Sure, we vehemently disagree that the board withheld those documents, and we addressed that issue both in our brief and in our opposition below. There were multiple discovery requests. They were made to both the board and the town, which is not a party. The board objected to those requests. They specifically directed the plaintiffs that they may go review other town files at town hall and put that notice out there. There's absolutely no reason why a volunteer zoning board should be expected to be responsible for producing records of every single town board, department, and commission. And frankly, I think the DEFRONZO's argument on this is quite specious. They served 5 subpoenas on specific town departments. There's no reason, if they're specifically asking for documents from specific town departments, that the board should infer that their response was supposed to be all encompassing. I think the board more than fairly put them on notice that they were producing the board's records, not the building department's records or anybody else's records.
And so a subpoena did not go to the health department?
No, you're right. The Board of Health is not one of the departments. They never sought Board of Health departments. Their argument now is that because the Board of Health and the building inspector share an office, that the zoning board had an obligation to produce Board of Health records. Frankly, Your Honor, I really think it's almost unfair to even have that allegation out there against the board, particularly the objections they raised in discovery that specifically put the DeFronzos on notice that they were free to go to town hall and review any records they wanted of other departments. They didn't do that until after summary judgment issued.
We have a finding by the motion judge in the record anyway at footnote 3 of the denial of the motion to reconsider, correct?
Yes, Your Honor. And he, I believe the motion judge agreed with our position. He makes a reference to the reasons that we gave in our papers.
I'm not sure I understood Mr. Cornetta, but I think what he seemed to be saying there is an email that showed that actually the correction permit was transmitted to one of the agencies that was subpoenaed.
Apparently, it may have been submitted by email many number of years ago, and when they subpoenaed the file, they didn't come up with it. There's nothing to show that they came back and actually found in the file and it was withheld. It's possible that an email from 2012 got missed. When this happened, but none of those materials are in any way relevant to this matter regardless. Nothing about a Board of Health correction order changes the meaning of the 2012 permit. And frankly, his client shouldn't be benefiting from the fact that instead of coming in and just asking for applying for the building permit to do the work, their predecessor only did it after being forced to through a correction order. I really don't think the law would favor giving a higher benefit to a property owner who's been ordered to make his property safe versus one who does it voluntarily. But in addition to being, our position being that we produced everything that we had and were available to produce and that was reasonably sought, none of the additional materials they obtained from the Board of Health change anything in this case.
I see you're out of time, but with the panel chief's permission, I have
Absolutely, Justice Neyman.
Thank you. I want to go back to the first or second question I asked your brother, which is the judge said in his summary judgment decision, this case hinges on whether the 2012 permit authorized use of the property as a multi-unit dwelling. Attorney Cornetta agreed with that, although he changed the phrasing of multi-unit dwelling to, I think, for residential purposes. Do you agree that that is a correct way to outline the key issue in this case? Is that a correct statement of the issue at hand?
Well, I have two responses to that. First, I agree with, to the extent that we're talking about the 2012 permit, I agree with the lower court because there are different types of residential use in the zoning bylaw. Multifamily is one of them. And so I don't think saying residential generally, as Attorney Cornetta had said, is quite specific enough to trigger any legal requirements. But again, in framing this case, I still think the fact that an unlawful use never becomes unlawful has to be part of that question. And so I just want to reserve on that point. But as to the 2012 permit, I would agree with the lower court that there's nothing that references multifamily in any of these papers.
So I understand your point more succinctly. You're saying the 2012 permit is irrelevant to the ZBA's decision, but if we decide to reach that issue, then the rest of your answer stands. Is that correct?
Yes, right. I think it's irrelevant, but if you choose to reach it, I think that under Cape Resorts, it is not an original building permit, and none of the papers that have been submitted change that.
Okay, thank you. Thank you both.
Council, we will have to leave it there. I want to thank both of you for excellent briefs and excellent arguments. This is a very interesting and difficult case, so thank you both.
Thank you.
The case is now being live streamed.
Thank you. Our next case is John Doe number 308290 versus the Sex Offender Registry Board, docket number 19P1394. Counsel, I remind each of you that this case is impounded, so please only use pseudonyms. With that, Attorney Goldblatt, when you're ready.
Thank you, Justice Blaze. Is 4-year-old information new information, as the term is defined in General Law, Chapter 6, Section 178L, triggering reclassification procedures? The plaintiff argues no. 4-year-old
Before we
information.
get into the substance of your arguments, which I want to get to, perhaps you could first address the question of waiver. The board says that these claims are waived because they weren't raised below. And you respond, I believe, in your reply brief that they're jurisdictional and can't be waived. Do you have a case that says that in the context of SORB cases?
Yes, Doe v. Sorb, 82 Mass Appellate Court 152. It's an almost identical issue, which is a case where the SORB gave itself in regulations greater authority to reclassify, to initiate reclassification procedures than the statute had allowed. And the issue was heard for the first time on appeal. The appeals court panel looked at the issues before it and agreed that, first of all, it was not an issue that could have been raised profitably before the hearing examiner, because the hearing examiner is required to apply the rules as they exist. So there was no point in raising it for the hearing examiner. Then the question was raised whether the issue of whether there was a requirement that it be raised through a declaratory judgment action. And the court held no for two reasons. One, the declaratory judgment rule is not mandatory. It's not phrased that way and hasn't been interpreted that way. And also that in this case, in 82 Mass App Court 8152, in that case, there was nothing to be gained by raising it below. There were no evidentiary issues. There was just the question of, can the SORB give itself authority to reclassify under these circumstances?
Yeah,
there was no doubt.
I'm sorry, I'm going to interrupt. I'm looking at the case you cited. It looks like those issues were raised in Superior Court. Am I reading that incorrectly?
The court found that they didn't need to be raised through a declaratory judgment action, which was the only way they could have been raised.
Okay, I have to read the case then, which I can't do now, so go ahead.
So no, it's not waived. And basically the court has discretion to hear it because the declaratory judgment statute is discretionary. And if the court wants to hear it, it can. If it doesn't, then we'd be looking at an issue of ineffective assistance. But it'd be difficult to raise because there's this existing case which says you don't have to raise it below. So we'd be sort of between a rock and a hard place there, where on the one hand, I think there's a good reason not to raise it because there's this existing case law that says declaratory judgment is not mandatory. But also on the other hand, there's the, if this court then finds that it's not going to hear the issue substantively, certainly the plaintiff is in a difficult situation and that would need to be resolved in some way.
But as a practical matter, you're before the hearing officer, not you specifically, Attorney Goldblatt, but your client's before the hearing examiner, and he's saying, hey, I shouldn't be reclassified. There's a lot of things with respect to a level 3 that are different than at least the level 2 at the time of his initial classification. Isn't that the time to say, oh, and by the way, these things are stale and they're not new, and you don't have the authority to reclassify me based on them?
He certainly could as a courtesy, but the hearing examiner is required to apply the rules that the SORB promulgated, even if those rules are illegal. The hearing examiner
isn't staleness always an issue that someone in your client's position raises at the hearing examiner? Even if true, it's stale, it's old, it doesn't apply to me anymore, you should give it mitigating weight, you should give it low weight.
That's different than the issue he's raising here, which is not that all the information before the hearing examiner was stale, but that the triggering information, because a lot of information can be considered, but only some information jurisdictionally can trigger a reclassification.
So when you say that there's something that happened 4 years ago being new, I assume you're referring to the November 14th, 2011 assault and battery plea.
Yes.
Okay. So let's start with that date. You would also agree, would you not, that there was a period of time from maybe February of 2015 to March of 2016, where your client had moved out of Massachusetts. Does that, and this is my word, this isn't from a case, but does that sort of toll, if you will, the argument about what is new and what is not new?
I don't think so, no.
It doesn't matter that he was out of our jurisdiction and therefore not subject to the reclassification during that time?
No more than the fact that he wasn't subject to reclassification when the event occurred, because the
So
SORB did not
everything-
yet have the authority.
Everything stems back to the November 2011 plea from your perspective.
Yes, although there is an argument that there relatedly, of course, the plea then triggered a probation violation around the same time, which also triggered a bunch of things happened all at the same time.
Right.
And those would be covered under numbers 1, 3, and 4 of the then extant rules. But all of those were, by the time reclassification was commenced, stale. They were all old.
Well, that sort of segues into one of my questions, which is, does the record reflect whether SORB decided to reclassify your client based solely on the 2011 assault on his roommate, or based on other conduct that occurred after 2011?
Well, it would have to be the assault and the following adjudications related to it, because those are the only things that were sufficient to trigger a reclass under the rules. And yes, they did. The SORB did refer to that in, I think it's the record appendix on, is it page 418? I cited in the reply.
Yes.
I can just pull up the exact page for you now.
I don't want you to spend too much time on
I'm
this.
sorry. It's cited in the reply brief. It's the worksheet, the initial reclassification worksheet, which
Understood.
I cite and name as it. And that page has the reasons that the SORB acted. And it was, again, I don't want to limit it to just committing the new offense, because of course that triggered the probation violation, which triggered the incarceration. They're all 1, 3, and 4 of the regulations would have been implicated, but they were all stale.
Let me ask you a question that is probably difficult to answer, but when would it not be when would the information still be new? In other words, what if it happened in 2012, 2013, 2014? I asked that just to get a sense from you of when did it become a problem? Right? Because
I can't answer that.
We don't have a lot of cases that define what new means, right? You would have cited them if we did. So you say 2015 is too late. Is there a time between 2011 and 2015 that would not be too late?
I think within before 2014, I'm thinking, and the reason is that I'm thinking about that 3-year, every 3 years you're allowed to request reclassification, because there's an understanding that within 3 years your circumstances can really change. So I think a 3-year is certainly outside the bounds, but I also don't think that the legislature intended to give the SORB 3 years to act, because that would, of course, contradict the SORB's mission to maintain current information. So certainly by the time you've hit 3 years, we're done. It would be if there needed to be a hard and fast rule. But I also don't think that just because it's only been 3 years that we're necessarily free and clear. And in this case, because it's so clear that the SORB was acting because the law had changed and not because the facts had changed, I think that's a really unique situation where they're in a situation like that. It's, I guess I wouldn't say bad faith, but you're not looking at a situation where they considered this information for years and were really struggling with what to do about it, and then went ahead a little bit late, maybe. What you're looking at is they knew about this for years and years and years and just decided to go ahead when they thought they were allowed to. I would also,
Let me
yes,
just,
Justice.
before you move on, if they had sought to reclassify him at the time of the plea, that was 2 weeks after his initial classification. Would the argument then be, hey, you haven't given him a chance to show what it is you found under level 2 and that he can comply? This is too soon.
No, the argument then would have been you don't have the legal authority to reclassify him based on a conviction for something that's not a sex offense.
Okay, I interrupted you. I'm sorry.
Oh, no, I was concluding that remark.
And you say that the intervening change in the law never renders stale information new at page 19 of your brief. Is that, do we find that in any case law, or is that what you want us to decide here?
No, I think I did not find that in case law. I was summarizing my argument there. And the argument is that a change in law is not a fact. A change in Massachusetts law is by definition not information or a fact.
And can you address Attorney Bosse's argument that there were in fact regulations in place at the time of this reclassification hearing?
Yes, there were. I got confused because the court was continually citing the 2016 regulations, which had not been issued yet. And so that was a failure of research on my part. When Attorney Bosse cited regulations that the SORB was actually relying on, at least actually had the right to rely on, I guess is a better way to say it. Then the argument is, are those regulations lawful? And because those regulations, because they were in effect at the time of when the reclassification was initiated, and they're not because they specifically give the SORB more authority to initiate reclassification than it has under the statute. The statute says new information and the regulations say any information. And you're not allowed to do that. You have to stay within the statute.
I ask, are you making any argument that the level 3 classification isn't warranted on the facts as opposed to it's procedurally defective?
It's interesting to try to parse those. I think I know what you mean. And based on what you mean, no, I have not raised a challenge to the hearing examiner's conclusion. I think the hearing examiner properly applied the facts to the law, to the regulation that was in effect at the time, which regulation gave them the authority to start a reclassification at any time. But no, it was not factually accurate because the procedural problem infects the factual finding because you're looking at stale information to start.
Okay. And just a matter of fact, you would agree that you have this procedural issue you're raising, you didn't raise in Superior Court, you're raising it here for the first time.
Yes, the attorney who handled it in Superior Court did not raise it in Superior Court. There was no, it would have had to have been raised through a separate declaratory judgment action if it were to be raised at all. Because the regulations as written were followed. The problem is the regulations are ultra vires. So that had to be raised in a separate declaratory judgment action if it was going to be raised in Superior Court. It was not raised in a declaratory judgment action below.
Thank you.
Could I ask you, on page 33 of your brother's brief, he ticks through a number of things that he says makes the new information mitigating evidence from the level 3 to the level 2 to the level 3, that your client was not on probation any longer as a result of the subsequent plea and incarceration. He was no longer in mental health counseling. He was no longer in sex offender treatment. He no longer had a GPS requirement. He had an enhanced criminal record from that existed at the time of the initial classification, and he was no longer living in a supportive apartment with help. And he points to all of those as saying that's why reclass was appropriate in addition to the plea. And these things all obviously, I believe, are triggered or most of them are triggered as a result of the plea. Can you address that substantive issue?
I can, because I don't think that's quite what he said, because there's no evidence of that in the record that was before the hearing examiner. So the That's not part of the record. What happened was there was simply no new information mitigating, no new mitigating information was presented before the hearing examiner of his daily living, which is different than there was evidence that all these things were gone. And in fact, the hearing examiner made a finding on page 500 of the record. I think I have that page right again. It's cited in my reply brief, but saying there's no new information about his stability. There is zero new information about that in the record, and therefore I do not consider it. So I think that's an inaccurate summary of the record to say that there was all this new information in the record about his stability when the hearing examiner specifically finds that there's not.
Okay, I see that we're out of time, but I want to make sure that Justice Massing and Justice Neyman have no further questions. Okay, thank you very much. Attorney Barce, when you're ready. Oh, it looks like he's frozen.
Now he's back.
Are you back with us? There we go. Okay. When you start to speak, the clock will begin.
Good morning, Your Honors. May it please the court, John Bosse for the Sex Offender Registry Board. The SOAB respectfully requests that this court affirm the hearing examiner's decision to reclassify the appellant to a level 3 sex offender.
Can we start with the question that you raised in your brief of waiver and your sister's response to that?
Sure. Thank you, Your Honor. With respect to waiver, the appellant did not raise that the SOAB lacked statutory and regulatory authority to reclassify him, as well as that the information was new. So because it was not raised at the classification hearing, as well as the Superior Court, it's waived.
Is it jurisdictional, as she claims?
Sure. So once I received the appellant's reply brief, I then drafted a 16L letter, and based upon the Supreme Judicial Court case, I find that in that case, the Supreme Judicial Court said that a matter of jurisdiction has to be raised before the board. Now, I also recognize that Attorney Goldblatt filed a motion to strike my 16L letter, and she cites to the Sex Offender Registry Board case that this court published on July 16, 2012, 82 Mass Appellate Court 152. And in that court, they said that because the hearing examiner did not have the authority to strike a regulation, then they concluded that the plaintiff did not waive his claim. However, during the appellant's argument, I went back and I read that case, and it appears that they did raise all the jurisdictional issues before the Superior Court. But I guess what I'm trying to get at is that in my 16L letter, the SJC case I cite to, it seems to be in contrast to the appeals court decision. And the SJC seems to state that because it is a jurisdictional issue, it should have been first raised before the board.
But I thought if it was truly, I'm sorry.
No, go ahead, Justice Neyman.
I was under the impression if we're dealing with subject matter jurisdiction, if it's truly jurisdictional, my understanding is it can never be waived.
I was of the same opinion, Justice Neyman, until I read the SJC's case in 3974, in which the court stressed that when a party neglects to raise an issue during an agency proceeding, the reviewing court lacks a record on which to evaluate questions of statutory authority or jurisdiction.
Okay, we'll give it another read. Thank you.
Yeah, and just to let the court know, it seems to be in sharp contrast to the appeals court decision. So I just believe that that's an issue that the court has to review both cases and, you know, determine if the SJC case precludes the appellant from raising these arguments for the first time on appeal.
I
As a
understand.
practical matter,
Correct.
what would Doe do to raise it below? How do you raise these issues below?
Well, Joe would have had to made the same arguments that the appellant made by
To the
stating
hearing examiner.
correct.
And do you agree with Attorney Goldblatt that an action for declaratory judgment is discretionary or at least not mandatory to be filed?
In the Superior Court, if a party is looking to declare a SORB regulation unconstitutional or beyond the board's authority, the case law stresses that a declaratory judgment should be raised below. And that's, I don't know if it's an SJC case. The Doe number is 10800, but it was an SJC case from 2011 in which the appellant was trying to argue that the SORB classification scheme is unconstitutional, and the court stressed that it was being raised for the first time on appeal, and the proper action should have been a motion for declaratory judgment. Now, I should also note that I argued a case back in 2019 before this court in a published decision. Justice Milkey, in a concurring opinion in a footnote, he wrote about, I state no opinion on whether an action should first be made. You know, if you're going to challenge a board regulation, he stated no opinion on whether a declaratory judgment action should first be claimed in the Superior Court.
So maybe if we could move to the substance for a bit. Your sister says 4 years is too long.
Mm-hmm.
What do you say?
Sure, Your Honor. Because the appellant never raised these issues below, the SORB never had an opportunity to show that based upon, we have a database, and based upon SORB's database in 2012, based upon the sexual assault against the victim, the SORB did consider moving for reclassification. But then
back in 2011.
That's correct, after 2011. But then, and again, this is based upon information in a SORB's database that we share with law enforcement. But the problem is that once the appeals court decided the case of 82 Mass Appellate Court 152, they told SORB that we can't reclassify unless we have a new sex offense conviction. And so as a result, we put a stop to the reclassification in 2012. But then subsequently, after 2012, we couldn't simply ignore all of the additional misconduct that the appellant was engaging in, including in 2013, the domestic assault against his roommate. And then in 2015, we were looking to hold the reclassification hearing, but the appellant moved out of state to Georgia for some time. Upon moving back to Massachusetts, we eventually were able to schedule the hearing, which I believe, I apologize, it was either in 2017 or 2018 that the hearing occurred. But we were able to eventually schedule the hearing. But this court has also got to keep in mind that between 2016 and 2018, we had to conduct a number of new hearings because a number of hearings were remanded because of in December of 2015, the SJC changed the clear and convincing standard.
So we're analyzing the issue of classification based upon new information within the meaning of section 178L, section paragraph 3, correct?
Correct.
So where's the limiting principle here? I mean, what you state in section 3 of your brief is the information used to reclassify Doe was new because it arose after Doe's original classification. I don't know that there's no limiting principle with that argument.
Right.
Do you have a limiting principle in mind?
I think you just have to look at it from the view of reasonableness, and you have to look at the facts of each individual case. So in this case, as I mentioned, the SORB was looking to reclassify in 2012, but then they had the this court's decision, which limited our ability. The new sex offense case triggered a violation of probation. So once the offender was released from the House of Correction on his governing sex offense case, then it was proper for SORB to look into reclassification, and we had to consider, we just couldn't ignore the ongoing criminality after his original classification hearing.
So suppose Doe was classified as a level 2 offender in 2008.
Correct.
And in 2009, SORB learns that Doe did something else in 2008 that was relevant to his risk to sexually offend. And SORB does nothing about it until 2020. Can SORB in 2020 say this is new information, so we're deciding to act upon this now based upon the conduct back in 2008?
Oh, Your Honor, that would be unreasonable.
Okay. Where does the term reasonable come from? Is that in the regulation? I understand you're just responding to my question.
Right.
Is there anything in the statute or the regulations that can help us sort of define what constitutes new information, or why the concept of reasonableness is the right standard to use?
I believe it's actually section 178L, in which they state that, and again, if you would permit, Your Honor, I can look at the statute now, but I believe the statute does talk about SORB has to move for reclassification within a reasonable time of receiving the new information. And I believe they use the word reasonable, but my memory is, and I can pull the statute now if you would like, Your Honor, but my memory is that the statute does tell SORB to move for reclassification within a reasonable time period of receiving the information that it seeks reclassification on.
But your sister makes a good point when I tried to get her to agree to a timeline, which she smartly did not do, but suggested that, 3 years, because that's when you can, the individual can seek a reclassification. That's, if we're talking about reasonable, that seems like a reasonable response.
And again, I truly believe that you have to look at it as a case by case basis. And
so let's look at this case, right? He did something, he pled out 2 weeks after the first classification, and then there's a litany of things that happen. Certainly one of which is that he left the state for a period of time. Another that you argue is the onslaught of those remands because of the law changing. Does the law changing, why should that punish, if you will, Doe in this situation? It's not his fault that the law changed, but you acknowledge, rightly so, that it took time for SORB to deal with that backlog. Should he be held responsible for that? Seems like he shouldn't be.
Well, again in 2012, SORB did look to reclassify him, but then this court said, no, Sorb, you can't reclassify unless he's convicted of a new sex offense. And then, and also in that court, in that case, this court said, however, if the legislature amends the statute that permits Sorb to move for reclassification, then Sorb is permitted to. So once the legislature amended the statute that allowed us to reclassify based on information that was new and relevant, we simply couldn't ignore the sex offense that he committed against his roommate that again occurred after his classification, occurred after his governing sex offense. And then we not only had that, but we had the information about the domestic assault against his girlfriend.
The 2013.
So, 2013, and he was placed on pretrial probation, and the case was eventually dismissed. He also had, because of the sexual assault against his female roommate in mid-November of 2011, that triggered a violation of probation in his governing sex offense case, and he had to serve a year in the House of Correction. So
was that from the 2013 incident, or was that from the 2011 plea?
I believe so. I believe it was from the 2011 case involving the girlfriend, because because the court in the governing sex offense entered a violation of probation in 2012.
That's what I thought.
Yeah.
Right. I see our time is up, but I want to make sure that Justice Massing and Justice Neyman have no further questions.
Any further?
Seeing none, I thank you both. Those were excellent arguments. The matter is deemed submitted. Thank you both. Thank you.
Thing is really nuts. All right. There it is. There it is. Hey, come on.
The case is being live streamed.
Okay, thank you, folks. This is our last case of the day today. It's called the Department of Children and Families and Another versus Father. It is docket number 19P 1545. In this case, the father is the appellant, and Attorney Yanoff is here by court order as standby counsel. The panel can ask questions of either the father or Mr. Yanoff, and if father does not use his entire 15 minutes and Mr. Yanoff feels there's anything he needs to add, we will let him do so, not to exceed a total time of 15 minutes. And I just remind everyone, this is an impounded case, so we should refer to people as father, mother, child, and things like that. So if you're ready, sir, when you say you're who you are, the father, the clock will begin. So, sir, when you're ready.
Now?
Yes, please.
I am the father. Do I mention my son's name? No.
Don't say your son's name, no.
Okay.
So tell us your argument.
My argument is that they have kept my son away from me for all this time. I hadn't signed no statements or nothing. I didn't sign nothing. And they kept him away, I believe, because they convicted me of parental kidnapping. When I never kidnapped my son, I seen my son with a total stranger, somebody I never seen before, never knew, and I treated my son. I've been a good father to him. I've never harmed him. I have another son who's older and a half daughter, and I've always been good to kids. I take care of all 4 or 5 kids now. They're my nieces and nephews from ages 12 and 2. All right, I have twins here too that I take care of. They're my nieces too. They're 7, you know. And I had visitation rights with my son. I had 5 of them. And I was late twice. They were late. The other 3 times I had to wait for him to come in there. But I didn't argue with nothing. No, I remained humble. And they just took my business away from me and broke our bond with my son. And I had a bond, and I got letters here right now from the foster parents. Their names, I won't say their names, but they're foster parents. And they sent me a good statement telling me how my son how much fun Bryson came home from his visit, and he was so happy with me because we were playing with dinosaurs and stuff like that. And he's very smart as far as dinosaurs. He lets me know the name of them all. Even though I knew the name of some of them, he's still very smart. I love my son with all my heart. You understand? I try to remain humble all these years, but any man or any woman would have did the same thing I did. If they seen their son with a stranger, they would have retrieved their son. They said I jumped the fence or something, and I endangered my child, but they never seen me jump the fence. The only reason that I pleaded to this case is because I was in jail for 2 years, and I still hadn't seen my son. My grandmother had died. I still held on to her mother, and my mother died. That's what made me give up. That's the only reason I gave up after 2.5 years. I was able to fight that case. And I didn't think I would get a bigger trial. No, not at all. I didn't think I had a jury of my peers. No, not at all. But I would have fought it if my mother hadn't passed away. She was my best friend. And I loved her so much, respect her, and I still love her. And it's still with me till this day. Now, she had seen my son, my mother. One time we brought him to a party, one of her parties for her 70-year birthday, I think it was. And both of my sons was there. But that was her first time seeing little Bryson. So she spent all night with him, all day with him, and everything. But when we got back to Boston, DCF shows up and says that my son's mother was drinking or something. And she wasn't drinking, you know. My son's mother was a good mother. And if she wasn't, I would have took my son a long time ago. Just like I took him from the strangers. There wouldn't have been no problem with me. But she was a good mother. And now they just totally tore her apart right now. She's good. So all 3 of the kids, we had activities. I worked every day, Monday through Saturday. I was able to provide for my kids and everything. Both of my kids providing the food, toys, clothing. I have 200,000 kids that kills me all the time. And I love my kids. I just don't understand how somebody can keep away from your kid for so long. Where is the justice at? And, you know, and then I got another thing about DCF trying to keep him away from me. They wrote a report that I harassed somebody in juvenile court, and I didn't get to say her name, but she's a DCF worker. I harassed her. It took like 3 months, but then they found me innocent, that I hadn't harassed her. And I asked my lawyer why did it take so long when they have cameras and everything. And then my other lawyer, he called the juvenile lawyer, called my lawyer, and let him know that he never said nothing to these people. He walked out of the courtroom alone. And they don't let you walk out together. So how could I say something? But I won the case anyway. That's just an example how DCF is trying to keep me away from my kid. Now, as far as the foster parents, I have nothing to say against them. They wrote me a nice letter, and I appreciated them. I don't know them. I never met them, but I know their names now through the letter. And they were great. So I have nothing against them. It's not that I'm trying to separate my son from his brothers and sisters. I'm not trying to do that. I just want to see my son. I just want to have a bond with him. You know what I mean? I just want business with him. You understand? I don't want to ever separate him from his brothers and sisters because we had them, they were all together, and they're still all together. But I do want that bond with my son, for when he does get out of that place or wherever he's at, he can come right to me, you know? I'm tired of looking at, I love my nieces and my nephews. They're all babies and stuff, and I love them, but when I'm sitting with them or babysitting them, it's hard for me, you know? And they can see it in my face, you know, I'm not as much fun as I used to be. But it's hard for me because Bryson's not there. Ryan is an adult. He comes whenever he wants to come, and he's good. He's in college now, community college. But Bryson, I'm sitting up here, I got all these kids, and I can't see my baby boy. You know what I mean? And they're asking me about him. My niece Cass, and she's the same age as him. So she's always asking about Bryson. When is Bryson coming? When can we see Bryson? I don't have an answer for him. You know, I just
Sir, can I ask you a question? Can I ask you a question?
Yes, sir. Yes, Your Honor.
So remember I refer to him as your youngest child. Okay, well, let's not mention the name. So yes. One of the things that the judge found was that when you were incarcerated, you know, the judge said it was inexcusable that DCF didn't try to arrange visitation while you were there, but the judge also sort of found fault with your lawyer for also not trying to arrange visitation. When you were in jail, did you try to arrange visitation? And you just got muted somehow, so you can have to unmute.
Turn on your microphone, Dad. Or Matt, can you?
Sir?
Oh, there we go.
So start again.
Well, I'm sorry, sir. Somebody was trying to call. I talked to the caseworker, and he had a DCF worker on the phone, and he called me to the office just like he called me when my mother died. And he says, DCF wants to talk to you, but when I got to the office, they had hung up. So he tells me to come back to the office, but they never called back. And he was the one who told me, he said, you seen me, sir? And he was the one who told me that they called, you know. The same person who told me about my mother's death and my grandmother's death was the caseworker. He alerted me each time. But when DCF called, he also alerted me. When I got to the office, they had hung up. So he was trying to contact them back, but they never contacted. Your Honor, but like, I'm not against nobody. But they arrested me. I felt like the Central Park 5. I got arrested for nothing, for protecting my own son, which I would do until I die, which I did for little Brian. I do it for Bryce, and I do it for my nieces and nephews. I love them all. I don't have no animosity against DCF. I'm very, very upset with them. But the foster parents, I'm not upset with them or nothing because they don't know what's going on. I'm not upset with them. They write me letters and they wrote me good letters. So I have nothing to say about it. It was DCF who destroyed me, destroyed my family, destroyed my job. And that's the problem. You can get another job. But this job was a good job, and my boss was good to my family. He was good to my kids. They would come up and visit me. And he wouldn't even mind as long as I did my work and closed the place up, you know. He never minded. I love the job. And I love to see my kids coming up here so they can see me working, pressing and stuff, so they can get an idea about working and stuff. You know, I grew up, Your Honor, in a house where my mother was a lenient mother. My father was kind of strict, but they always made us clean up. I learned how to do laundry at the age of 9. I was iron at the age of 11. Your Honor, I'm not this bad seed that they say I am. You understand? I never harmed a kid in my life, and I will never harm a kid. I saved a couple of kids in my life, but I never harmed one, especially my own. I don't do that. I don't do that. I don't mess with kids. I'm not a child molester. Of course, if they figured something like that out in jail because they knew I was there for parental kidnapping, they would have hurt me. That wasn't rehabilitation. These people were coming at people. And they didn't come after me because they said to me, well, you did the right thing. That's your son. What are you going to do? I didn't know these people. I'm not going to say their names, but they were new to me. But I did know a couple of DCF workers. And they kept saying, the day they took them, the day I got arrested, they sent a paper saying his mother was intoxicated. And I told them his mother wasn't even home. And they said, oh, we know. She was down at the state. And she went from there to DCF just to see what was going on. By then, I got arrested. I took my son, and I took him to the park. Then we went to the store. I brought him back to the house. His camper was not wet enough, and the DCF concludes that he was wet. No, he wasn't wet. I've been taking care of kids since I was 22. I'm 55 now. He was not wet for nothing, but they say he was wet and stuff. But in the report, the ambulance guys who told the truth said nothing was wrong with the kid. He was healthy. I brought him back. I didn't kidnap my son. I didn't take him to New York or nothing. I took him around the corner in Everett, Mass. To a store and then to the park and swung with him for a little while. He was enjoying. Sir, I am not this bad seed that they make me look out to be. You understand? I have had some bad things, and sometimes when you go to court, you can't win, and I don't expect to win. I don't expect justice at all. I never did, and I never will, because I see it. If it ain't on camera, even if it is on camera, you can't get justice. So I knew that they was going to come against me 5 or 6 against one person, and the witnesses I had that wanted to come, they work every day too. They couldn't even come, so they just terminated my rights without me even being there. I wasn't even there. My lawyer, I came up to the court, and my lawyer says to me, they terminate my right. I cried like a baby because I didn't sign the papers. And my son's mother, she did sign papers, and they promised her 2 visits a year. I think they never get the 1 visit. It's been like 5 years. She hasn't got 1 visit. So I wasn't signing up, and I don't sign too many things anyway, unless it's a health reason or something, like that. And I'm sorry to even take up the court's time, but sir, this is killing me. You understand? My mother's gone, who was my best friend, and my baby son's gone. And sometimes I think they did us, not trying to be funny, because I was black and his mother was white. She was a great mother. She wasn't a bad mother. I'm telling you, I would took my son. Neither one of my son's mothers are bad mothers. I'm not going to say the bad one's better than the white one, because she's not. I'm not the white woman I had. My son's mother, I talk to her every day just to see if she's all right and just to see how she's feeling and stuff, because I know she's going through a lot. It's not just me, it's her. She don't even know I'm in court today because she gets hysterical, so I couldn't even let her know. I wanted to, but I couldn't even let her know. And as far as the other kid's father, I'm not going to say his name, but he was great to me too. He was great to Bryson. He treated Bryson like I treated his kids. And when he died, that was 2 weeks before I got out. I didn't know what to do after that. It was like everybody's dying. I'm sick of it. I'm so sick of it. I just want to see my son. Why can't I see my son? My oldest son, he's 21 years old. He keeps asking me about his little brother, Bryson. Where's Bryson, Daddy? Bryson, where is he at? And I tell him the truth. DCF now. DCF hasn't been fighting for him. I tell him the truth. And he says, that's not good, Dad. No, it's not. And I'm so glad he didn't have to go through that. Or Bryson going through. I'm so glad. Because I was younger than him, and I had really, really just let it go. I try to remain humble. I am a Christian, and I pray a lot, but I almost gave up my faith. I almost gave up on God. I didn't want to talk to him. I didn't even want to believe because of this. How can a person go through this and have God on his side? So I figured God wasn't on my side. But as time consumed, I started going back to church, started praying because everybody around me was going. And I started developing another relationship with God, but it was hard. It's hard for me to pray, for me to even believe in higher power at all. My higher power is for me to believe it is you guys, the judges. That's who I get to see, and the majority of them didn't even care, man. The majority of them didn't care. They arrested me 4 times without a warrant, saying I had a warrant. And they got all these computers and couldn't figure it out. So when I went to court, I seen a Judge Johnson, who's deceased now, and he says to the people he doesn't have a warrant, stop bringing him in here. And then it happened to me in Cambridge, but I had paperwork there saying I had a warrant for this case with DCF. And then when I showed the paperwork, the judge said, "Oh, I'm sorry, Mr. Jones, you don't have a warrant." And I did tell him I'm going to sue next time, But they cleared me with the case anyway. And my lawyer, he should have been got it over with because they know I never threatened these people. I never did nothing to them.
Sir, I do need to interrupt you because your time has expired. But I think that the panel understands your argument. Next, we're going to hear from the lawyer. We're going to hold on. Don't go anywhere. I want you to listen to the rest of the arguments. Just put yourself on mute. Okay, sir, Matt, can you please mute the father's microphone? All right, next we're gonna move to Attorney Kip Hortzman, and you have 10 minutes, counsel.
Thank you, Your Honors. Carrie Kip Hortzman on behalf of the Department of Children and Families. We're asking the court today to affirm the trial court's very careful decision freeing this child to be adopted into his foster family with his siblings who have already been adopted into the family. I do not see the need or I don't see the need to go into the specifics regarding the evidence that the court found in terms of the father's unfitness in this case. I will respond to any questions that the panel has about the arguments raised in the briefs. But it's unusual to have a parent appear on his own behalf, and I respect the father's emotions in this case and his wishes. And I would rest on my brief unless the panel has some questions that I would be happy to entertain.
Seeing none, Counsel, we appreciate that, and we will take your arguments as set forward in the brief. Thank you. That would take us to Attorney Cohen, and you have 5 minutes. Let's just make sure Matt's ready. Okay, when you're ready, Attorney Cohen, if you could unmute yourself. And when you start, the clock will appear.
Yes, David Cohen on behalf of the child. Thank you. So child is asking this court to affirm the trial court's termination of father's parental rights and approval of his adoption by pre-adoptive parents. As laid out in my brief, the trial court certainly satisfied due process, and there was clear and convincing evidence that father was unfit to parent the child and would like that.
Do I understand from all of the filings of late that you're going to address the issue of visitation between father and his son in the juvenile court in the first instance?
That's right, Justice Blake. So
okay, I just want to make sure father understood that as well.
That's right. So child, through child's trial attorney, has filed a motion in the trial court now. Great. For visits of up to 2 visits a year and some contact with father, which child, on behalf of the child, I'm representing that position, and child's trial counsel is representing that position in the trial court as well. We think is in child's best interest. Child has expressed a preference to see his father, and it's my understanding father knows that. So there will be a hearing over the next month or two in the juvenile court on that issue, but there's no need for this court to hear that issue and some of the unusual legal issues there with child's request to this court previously to hear that issue beyond a 1-year deadline in terms of Mass Rules Appellate Procedure 14. So that's correct.
We will have to address it in the because the father also raises it. So we will have to address it on the father's brief.
That's right.
Have you scheduled that date yet, or not? Is it not yet?
I am not sure if it's been scheduled. That there was a date later this week, I believe, for like a preliminary Zoom hearing in the trial court. I wouldn't be prosecuting that that motion. It was filed by the child's trial counsel. Although, I am trying to stay informed of what's happening. And then if there's an evidentiary hearing to be held, I think it would be held within the next month. So, I mean, if this court affirms the rulings below in all respects, and again, that does not mean that the child is still going forward on child's initiative in the trial court. Obviously, it would require some kind of willingness by father, agreement by father to do those visits, which I'm hearing today father is willing to do, and I certainly hope he's willing to do. Child would not, though, say that father would be a party to that hearing at the juvenile court level, given that his parental rights have been terminated. I think that's adoption of Nate, 69 Mass Appellate Court 370. At least with respect to a 29B hearing, father wouldn't have formal rights as a party there, but perhaps an affidavit from father that he's willing to participate in those visits at that level would be helpful. And the court hasn't progressed to that point at this point. But if father is willing, I can pursue it through counsel or through father as appropriate.
It sounds like that would be a good plan, counsel. If you have nothing else, I want to make sure the panel doesn't have any additional questions.
Oh, no questions. Thank you all.
Thank you, everyone. The case will be deemed submitted and you will get a decision in the mail. Thank you all. Take care. This is the end of today's sitting of the appeals court session. Thank you.
Thank you.